Good morning, everyone. We're going to do some basic introductions, and we have one more slide to put up. We have closed captioning available in the room, which if you would like the closed captioning, we have a link for you that we're going to put up here in just a moment that you can use then to access that with your own smart device. We'll probably still have some people coming through the door for the next 5-10 minutes, but we do have a lot of information to share with you today. I'm Chris Collins. I'm the Director for International Student Services here at Purdue University. Amanda Thompson is over here to my right in the shadows. Amanda is the one who actually staged this entire event for us, so thank you so much, Amanda. I told her I felt like it was all she did for 3 days, but we felt like the information was important enough. We wanted to get it out as quickly as possible with coming from the right resources. We have Angela Adams, attorney and managing owner of Adams Immigration out of Indianapolis, here with us today. Amanda Thompson and I can talk to you about some of the issues and immigration matters surrounding your Purdue-specific programs, but there's a limit to what we can share with you with regard to what's going on with immigration in general and United States Citizenship and Immigration Services. So we asked Angela to join us today to speak about the most recent event that was announced just a couple of weeks ago. So we would like to thank the Office of the Provost, who has been strongly supportive of this event, and Dr. Peter Hallenbeck, who helped fund the closed captioning for this morning. So without further ado, we're going to let Angela take it away, and we'll get that closed captioning slide up here real soon.
Thank you. Okay. Thanks, Chris. Appreciate it. Now, do I use this mic or do I use my lapel mic? Is he? Okay. All right. So, good morning, everyone. How are you? Good. So, we're going to try to give you some facts today. We don't want to get into the weeds too much on the public charge issue, so I'm going to try to keep it at a higher level. If you have specific questions, we would be happy to answer those, whether it's in this forum or after. If it's a very individual, specific question, you might want to hold that for a follow-up conversation later. Do we have the PowerPoint? Oh, got it. Okay. And the other thing I want to just mention is a couple things. This public charge issue is a very new announcement, right? And so we in the immigration community are still learning about it. It has not gone into effect yet. So bear with us as we as well are trying to learn along with you, trying to get ahead of the issue so that we can answer your questions today. This will help us to understand what your questions are and how we can better address the issue and how Purdue can better address the issue internally as well. The other thing I will say is that this issue could be controversial. We're not here to discuss whether immigrants should or should not receive public benefits. This is not why we're here today. We are here to give you information, to show you what the upcoming rule might look like and how it might impact you as a student, scholar, or faculty member of Purdue University. So please, with that in mind, there's no position, there's no political, angle to any of this. It's fully informational. Okay, so history of the public charge rule. The public charge, even though this is a recent announcement, I want to be very clear that public charge is not new. We, as immigration attorneys, have always, to some degree, had to evaluate cases and provide information on public charge. Whenever anyone applies for adjustment of status to come to the United States to become a permanent resident, to get a green card, we always have to fill out a Form I-864, which is an affidavit of support, to show that the person, the sponsor, makes enough money to support that person, the intending immigrant, as well as their whole household, their full household, that they make at least 125% above the poverty guideline. This has long been a requirement that we follow with all green card applications. So some of this is not new. It is merely, much of it is enforcing an existing policy, but also, and sometimes you have to understand the politics of it, right? It also is political in nature. And so the other thing is whether or not this new expanded view of public charge, it does provide more restrictions and limitations and add some things to the list that weren't on the list before. We're going to talk about that today. Also keep in mind that this is not final, although it is supposed to go into effect October 15th, it very well will be litigated in court and challenged in court. So we have yet to see whether or not it actually goes into effect on October the 15th. A court could enjoin it. Enjoin means stop it temporarily from going into effect. So with all that in mind, so public charge is not new. Public charge was previously defined as an individual who comes primarily dependent on the government for subsistence. Dependent on the government is demonstrated by the use of cash benefit programs. Mostly, it's not like credit card debt in the past. Was it credit card debt, not student loan debt, not any of those things. It's mainly federal public benefits that you have taken, and then the person would be held liable to reimburse the government if they ever became a public charge. The last major changes to the rule took place in 1996 through the Illegal Immigration Reform and Immigrant Responsibility Act. And that's when we started using Form I-864 with all adjustment applications to become a green card holder. The new rule will take effect on October the 15th. So the new public charge rule definition is a ground of inadmissibility that could bar an individual's admission to the United States to get a green card, or in some cases to change status from one non-immigrant status to another non-immigrant status. An individual who becomes primarily dependent on the government for subsistence or use of public benefit programs, in this case now, how it's changed is now we're counting monetizable and non-monetizable benefits for income maintenance or by institutionalization for long-term care at a government expense. The legal standard is whether the applicant is more likely than not at any time in the future to receive public benefits. So it's not just have you received, are you now receiving, it's are you likely to receive in the future, which is a very subjective, discretionary standard, right? Therein lies the open for interpretation. The rule targets low-income immigrants who have received one or more designated public benefits for more than 12 months in the aggregate over a 3-year period. Individuals applying for admission to the U.S. or lawful permanent residency are subject to public charge unless they fall under the exempted categories. We'll talk about exempted categories in a minute. How is public benefit defined? An individual must use more than a certain amount of specified benefits to be considered likely to become a public charge. Monetizable is something with a cash value. DHS will set the amount at 15% of the federal poverty guidelines for a household of one, so that's 1821 and 2018, used or received within 12 consecutive months. Non-monetizable, those that are non-cash, public benefits that cannot determine a cash value. The threshold is time-based, which equals receipt of one of the specified benefits listed in the next section for a cumulative of 12 months in a 3-year period. In cases where an individual receives a combination of monetizable and non-monetizable benefits, then the threshold for receipt, it drops to 9 months in a 36-month period. So here is a list of monetizable public benefits and non-monetizable public benefits. I'm going to move around here. So you can see that some of these, and keep in mind, some of these are not new. They've always been on the list, okay? Like the first few here, SSI, TANF, other local cash benefit programs, SNAP, housing vouchers, Section 8. I don't think those were on there previously, but the first few have always been considered to be on the list of public charge and benefits. Non-monetizable, this is where we this is the new and improved version of public charge, if you will. Benefits that DHS cannot determine. Again, non-emergency Medicaid. We're not talking about emergency room Medicaid. Emergency room Medicaid is different. We're talking about non-emergency Medicaid. Exempted from that is Individuals with Disabilities Education Act, the IDEA. Premium and cost sharing subsidies for Medicare Part D, institutionalization for long-term care at government expense, and subsidized housing under the Housing Act of 1937. Again, that's kind of the new category there. What public benefits would not count? Government assistance that are provided to the public more generally, like public education, disaster relief, tax credits, deductions available to the general public, public health assistance for immunizations, certain benefits that the U.S. is required to pay by reciprocal agreements. Excludes Social Security based on work history, government pensions, other employee benefits, workers' compensation, unemployment, veteran benefits, certain disability insurance, and general Medicare benefits. Who is subject to the public charge rule? Foreign nationals applying for a visa to come temporarily or permanently to the United States must show that they are not likely to become a public charge. And those in the U.S. on a non-immigrant visa applying for a green card. So we know that anyone applying for a green card must show that they are not going to become a public charge. What becomes more uncertain is people changing from a non-immigrant visa, like an F1 student visa, to an H1B, for example. That's less clear at the moment because it's not actually required, but it could come into play. Those subject to the rule: immediate relatives of U.S. citizens, relatives of U.S. citizens eligible for a visa under family preference categories. So if you're applying based upon a family member, basically, for a green card. Spouses, minor children, and adult unmarried children of permanent residents. Foreign nationals coming on immigrant visas through employment-based preference categories. So any of you who are here at Purdue as an employment-based and seeking a green card, you're on an H-1B and you're going to be seeking a green card through employment. This could impact you. Immigrants who won a visa through diversity visa lottery, fiancés, and certain non-immigrants. Who's exempt? Refugees, asylees, and several categories of immigrants in permanent or temporary status that mostly humanitarian, such as Cuban, Haitian entrants, juveniles for special immigrant juvenile status, SIJ, and applicants for temporary protected status, TPS, if you've heard of TPS, and others. How will the new rule be impactful? It will limit those who, well, arguably, this is some ways that it could impact the, I'm trying to see, I got some notes here that I wanted to, yes, okay. Okay, so how will the new rule be impactful? It will limit those who can come to the United States and change from one visa to another, potentially. The definition has broadened. So it's broader than it was before, now stating that the likely at any time to become a public charge. So you have to prove that in the future, you are not going to become a public charge based upon a totality of circumstances test. So look at the last bullet, shows you the 7 factors of the totality of the circumstances test. So how are they going to show that someone might become a public charge in the future? They're going to look at all the factors. They're going to look at your age. Are you between the ages of 18 and 65? Are you eligible to work in the United States? I know, I see heads nodding and doing things. So age, health. Are you healthy? Are you taking public benefits for long-term care? Family status. Do you have members of your household who are working, who can work and help you meet that poverty guideline, that threshold? Resources and financial status, assets, education and skills. Do you have education? Do you have a degree? Are you going to use that degree to work in the future? Prospective immigration status and expected period of admission, and affidavit of support. Again, let me just say, those of you who think who are shocked by this, it's not terribly different than some of the things that we already ask our clients. In the case of getting a green card, if you don't meet the poverty guideline, 125%, and this is under the old rule, then you have to get a joint sponsor. You have to find someone else who can file an affidavit of support on your behalf and show that they make enough money to support their household plus one, the intending immigrant. This has long been, we do this all the time. So, not terribly different. You're looking at household members. Can household members contribute to the income? Do you have an outside joint sponsor that is willing to sponsor you? Those kinds of things. So this, again, this is new, the totality of the circumstances test, and it sounds a little intrusive, looking at age and things like that. And we don't yet know how this is going to go because it hasn't been implemented yet. So we have yet to see how in the actual practical application, how this will be applied, okay? So what is this totality of circumstances test? Prior to the new rule, the focus on public charge was through the 864, right? Filed by one or more sponsors. Now the focus shifts to the intending immigrant, so the person who is coming to the United States. So we're still looking at the sponsor, but we're also going to look at the intending immigrant, the person who's coming. Are they going to work? Are they going to help support their family? Are they going to, receive public benefits? So they're required to file this new form, okay? This is kind of a big deal because it's going to require an additional form that I think is like 18 pages long for us as immigration attorneys and you as the intending immigrant to fill out to show that you aren't going to become a public charge. This is Form I-944, Declaration of Self-Sufficiency, which shows your work history, work skills and education, English language ability, financial circumstances, assets and financial liabilities, and applications for receipt of public benefits. So, also want to mention one thing. People have asked, is this if you've received, or even if I've just applied for a benefit, but I never received a benefit, will this apply to me? And the answer is maybe. I know. It depends, right? I love that lawyer answer. Okay, so it could be. It's part of the totality of circumstances test, which could be taken into consideration when determining whether you are likely to become a public charge. They can take into the equation, have you ever applied for public benefits in the past? It will not weigh as heavily as if you actually received public benefits, okay? So, but it's part of that factor test. Another thing I want to mention is failure to file this form, I-944, will result in rejection or possible denial of the I-485. Usually if you leave out a form in your application, it will be rejected. So we get, if we file the wrong filing fee, or we send the wrong form, or the form's not signed in the right place, or whatever, they tend to reject it and send it back to you so that you can correct the error and send it on. Hopefully they won't just outright deny the 485 because then that means you'd lose your money. So rejection means you get your money back and you can send it again. Denial means they cash your check and they don't give it back. So make sure you file this I-944 if it goes into effect on October 15th. Another thing I want to mention, and this is also uncertain, but what I understand is that income gained through unauthorized employment, for example, someone is in the country undocumented and they're working with a false something, false documents or working under the table or something, that income can be considered in order to put you, above that poverty guideline. That's what I'm understanding. But again, still not certain on that. The other thing that I want to mention is this applies to only if you're adjusting status in the United States to get a green card. It does not apply necessarily if you're outside of the United States doing what we call consular processing. Consular processing is when you're coming from abroad to enter the United States. So keep in mind, this is a DHS, Department of Homeland Security, USCIS rule. Department of State is a completely different agency that runs the consular processing outside of the United States. As of right now, this rule is only if you're in the United States applying for adjustment of status, okay, to get a green card. What we have heard and have not yet verified is that possibly Department of State will be revising its public charge guidance in the future, but for now, we are only talking about inside the United States applying for adjustment of status, okay? Okay, so DHS will only consider these public benefits that are listed in the rule. You saw these on a previous slide too, but here they are again, okay? SSI, cash assistance for income maintenance, TANF, general assistance, federal, state, or local cash benefit programs, SNAP, formerly called food stamps, Section 8, project housing, public housing under Section 9, and federally funded Medicaid, excluding emergency room assistance, okay? The exemptions, again, emergency room, we talked about this before, the IDEA, certain education benefits, school-based services, beneficiaries under the age of 21, and beneficiaries or benefits received by pregnant women would not be considered as well. Okay, how does this affect international students? So some possibly international students may have received or applied for certain benefits that could impact them if they go to apply for a green card in the future or change of status. This does not include Pell Grants or other forms of educational assistance. One thing that we're concerned about is that the confusion, the reason why you're all here today, right? Because you want to understand this better. That's great, because a lot of people may not understand this and may just immediately withdraw or cancel their benefits because they think they're afraid that that might go against their public charge when they're actually eligible for this benefit that they shouldn't cancel. So we're worried that there may be some confusion over what benefits would actually count against you and what benefits would not count against you. As you can see, the list is a little bit confusing, and the subjective test is also very confusing and discretionary. So there is some concern that students who are actually eligible for things might, or even faculty members or researchers might consider not accepting those benefits for fear that they might impact their future ability. So same, last one. Okay, how does this affect pregnant women, children, and aliens? I don't like the term aliens, so just FYI, I'm going to change that on this slide because we try not to use that term. Even though it is in the law, we try not to use the term. Enlisted in the U.S. Armed Forces. Immigrants and their children may drop out or forego enrollment. We've already talked about this, for which they are eligible for fear of immigration consequences. And this may cause worse health outcomes. If someone's not seeking treatment for a bad health condition, then that affects the whole community. Arguably could be a health concern, right? And people wait. They'll wait until it gets really, really bad until they can go to the emergency room because that's the only thing that they're eligible for. So that's a concern. As I said, which is not on here, pregnant women are exempted from this, benefits received by pregnant women. And also, if you're enlisted in the U.S. Armed Forces, DHS will not consider receipt of public benefits for the periods of time in which they are serving in active duty or reserves, and will also not consider for the spouse and children of such service members. Also not on this slide, but will be added, you are not penalized for household members that receive public benefits. So we get, and this question is not new. We've long heard this question, well, what if I got benefits for my children who are U.S. citizens, but I am not a U.S. citizen? Will I be penalized for that? And what my understanding is at the moment is the answer is no. You will not be penalized for your household members who are eligible for receiving public benefits, okay? And that has not changed. Okay. One other thing I want to add here, and here's some additional information, and I don't know if we can get this to you so you can, but these are really good. USCIS has some information. This is a great one, National Immigration Forum, Proposed Public Charge Regulation Summary, and then the Immigrant Legal Resources Center has a toolkit, some things you need to know about public charge, some downloadable fact sheets that you can pull. I also want to mention that two more things that are not in the presentation. Number one, this brings back what are called public charge bonds. So a bond is something that has never actually, it was part of the law, but never actually was implemented or didn't go into effect. Now this is saying that if you are likely to become a public charge by someone's determination, that you could potentially overcome that by paying a bond of $8,100 to the government, which is actually returnable. You can get that back later. So we have yet to know how that whole bond thing is going to work, or even if it's even going to go into effect, but there is that. So if you hear about public charge bonds, that's what that means. The other thing, be ready if this does go into effect and you're working with an attorney, your attorney may ask you for additional items such as tax transcripts, credit reports, documentation of your assets or liabilities, documentation of your health care policy, your insurance, child support documents if you're divorced and your ex-spouse is contributing to the household income. Child support documents would be relevant. And anything else that would help either prove that you're not likely to become a public charge or demonstrate that you have the financial assets or income to meet that poverty guideline, that threshold. So if this goes into effect, myself and other immigration attorneys will be modifying our document list of what we're asking for. Now, some of these things we already asked for. We already asked you for tax returns. We already asked you for documentation of assets if you didn't meet the threshold income guideline. But some of these things are new. Like, I've never asked a client for a credit report. I've never asked a client for a health care policy. That's just not something that we normally do. So this could be an additional item that you might have to provide in the future. One other thing is there's still that joint sponsor. So if you or your spouse, your family does not qualify for the affidavit of support based upon your income alone, sometimes in some circumstances you can still get a joint sponsor, someone who can show that they are willing to back you, and they have to sign that contract and prove that they make enough money to support their family plus one. The other thing you can do is, in this rule, there's still the 125% poverty threshold guideline, but it does mention a 250%. The 250% poverty guideline is what they call a safe zone. It's not a requirement. Okay? It's not a requirement that they're not increasing this to 250% above the poverty guideline. We were really concerned for a moment about that. What it means is that if you can prove that you make 250% above the poverty guideline, then you're in a safe zone. That means you should not, that in and of itself should prove that you're not going to be a public charge. Okay? So if your income is high enough that it's 250%, then again, you're in a safe zone, quote unquote. Again, these are all new terms. So, I think, and here's my contact information if you have any questions. And what we are going to do now is try to, well, I have a long list of questions brought to me. Thank you. Okay. These are beginner questions. Okay, so we have some questions here. Maybe we'll answer your question if you're lucky. I'm getting benefits now. What should I do? And please feel free to chime in over there, sitting in the shadows. Okay, I'm getting benefits now. What should I do? Well, it depends. Because it depends on what benefits you're receiving. Okay, that's my first question to you, is what benefits are you receiving? Are you eligible for those benefits? Okay, hopefully the answer is yes. Because if you're not eligible for those benefits, I'm going to tell you, don't receive them because you're doing something that's not right, okay? Probably illegal. So make sure when you apply for a benefit that you're actually eligible for the benefit. And if you're eligible, then I have less concerns because you could be a test case and sue the government for having to terminate something that you're actually eligible for. So I would say if you're eligible, I'm not that concerned. If you're not eligible, and a lot of time and in my experience, keep in mind I see a lot of people, a lot of different types of cases every day in my office. And we help a lot of different types of immigrants in different categories. For the most part, the vast majority of people that we work with are not receiving what's on the list of public benefits, okay? And the reason why is because most of the time you're not eligible to receive most of those public benefits, okay? So again, the question is about eligibility. If you're eligible and you're getting a public benefit, then let's talk about it. And don't terminate it just because you're afraid of how it might impact you. There are ways to overcome that, okay? If it's even on the list, it may be exempted. School lunch, free and reduced lunch, should not impact you. So if your kids are getting free and reduced lunch, I'm not that concerned. That's okay, okay? It just depends on what benefit it is. If you went to the emergency room, that's okay. You're eligible for that. I had benefits in the past that might qualify. What should I do? Well, I would say what's done is done, right? You can't outdo that, but you can overcome it. So overcome means you're going to, look at your whole package, the totality of the circumstances test, and you're going to make sure that now you're in a better place. Now you're able to, support your family or have someone else support your family, and that you're able to document that income. Next question, will anything change when I file an I-539 for my family? I-539 is a change of status for an H-4. It could be for a person on an H-1B and has a spouse or family members that are accompanying them as dependents on an H-4, or a 539 could be a change of status on a student to another category, or a reinstatement case for a student, something like that. So right now, again, what we're talking about applies to adjustment of status when you are applying for a green card. The 539 is not an application for a green card. We have yet to see how this will impact non-immigrant classifications. They could ask questions about that. Do you have any information to add?
The only thing I've heard is that the rule references admission, and they are keeping the door open to changing those forms to ask these questions. There is also a reference somewhere that they can issue a request for evidence.
Yes.
For documentation relating to public charge.
Yeah. So again, we have to wait and see what happens. But for the time being, I would not advise you to do anything differently in terms of filing a 539 for your family members. Because as of right now, that is not a requirement. And the 944 form, that is not a requirement. That's only with adjustment of status. Number 4, will anything change when Purdue files my I-129 H-1B petition? So if Purdue is employing you and filing an I-129, same answer. Same answer. Non-immigrant visa, different requirements, not an adjustment of status to get a green card, so you shouldn't have to file the 944. Again, we'll see what happens in the future. Will anything change in my visa application? Yes. You will have to file that visa application. I'm assuming this means green card application. So if you're applying for a green card through adjustment of status, whether it's family-based or employment-based, yes, you will have to file this 944 form as of October 15th. So there is, some people are thinking that there's a little bit of an urgency to get your case filed before October 15th. I will leave that up to you and your attorney and your department to decide. I personally am not that concerned about getting those cases filed before October 15th, unless I see that there's a reason to do so. So when I evaluate the case, if I see that there's some issue, then I'm gonna speed that along. Otherwise, we're just talking about another form, which is probably gonna cause us to have to spend more time and charge a little bit more. So your attorney may have to charge a little bit more for the time it takes to fill out this 944 form.
Angela?
Yeah.
We actually had a student dependent denied a visa at the embassy because they had received benefits related to a pregnancy.
Ah.
So what would your recommendation be in that scenario?
Uh-huh. So, and I've seen this too, so, and this goes back to your question, Department of State has their own guidelines in terms of what impacts consular processing. When you're outside of the United States, coming in either as a student or even as an intending immigrant, what will be considered? And we did have someone the other day who's married to a U.S. citizen who got the very first public charge decision I've ever seen in my whole career was based upon he did not meet the threshold, and he had a joint sponsor. But apparently the attorney, who was not me, did not do the right documents or something. So they got dinged on that. So I think it's harder, arguably a little bit harder when you're outside of the country for us to get in the middle of everything because there are less avenues for us to intervene in that situation. So if you're going outside of the United States, make sure that you have all the documentation to at least to prove it. You may not be asked about it, but at least to try to prove it. In that situation, I'd have to look at the Department of State guidelines because it shouldn't be held against her that pregnant or that her child had received benefits. Is that what it was?
She and the child.
She and the child, okay. Again, should not be unless she got something that she shouldn't have gotten. So, yeah, that's a little bit harder. Okay. I was told that the law permitted me to receive these benefits. Why has this changed now? It hasn't really changed. It's just they're trying to look at the whole picture of what qualifies, what doesn't qualify, and how that's going to impact you. And will you be able to overcome it in the future? Are you going to continue to be on public benefits, or are you going to make enough money to support your family? Next question, will I need an affidavit of support?
Angela?
Yeah?
Let me just add one point to that previous question about sometimes we've had situations where an individual has gone to a government agency and applied for a benefit and have been told they're eligible.
Yes.
And the government agency is in error.
Yeah.
And so individuals have received benefits that they are technically not eligible for. Unfortunately, the onus is on you as the individual who knows your circumstances to go check that list and make sure that before you apply, you really are eligible for that benefit. And that the government agency, they're a human being. Sometimes they're a kind person who wants to help out. If they make the error and approve you for a benefit you're not eligible for, you're the only one that's going to have the consequence.
Right. A lot of times the risk is only on you, and it's not on the university, it's not on the employer, it's on you. So you have to be really sure that anytime you're taking that risk that you know exactly what the consequences are going to be. Okay. Will I need an affidavit of support if I am being sponsored for a green card by Purdue through my employment? Yes, but usually it's a different form. It's called the I-134 form instead of the I-864, and usually it's to show that you as the intending immigrant and the principal applicant are going to be able to support your family members. If it's just you, it's probably not required because you're one person, but if you have a family of 5, they're going to want to make sure that you're making enough money to support your family. And it is my understanding that the I-944 form would also be required, even if it's employment-based adjustment of status. Will CBP, Customs and Border Protection, ask me questions at the border while I'm traveling? Potentially. It is always possible. CBP can always tell you to go, come over here, we have some questions for you. Those of you who have been through that know very well what I'm talking about. Not fun. Might miss your connecting flight. You always need to be prepared to answer questions through CBP at that port of entry. I am desperate in an unexpected situation, and receiving a benefit would greatly help me, but eventually I want a green card. What can I do? I cannot afford an attorney. So there's a couple things you can look at. You can look at nonprofit or agencies that do not charge for legal services, like Lafayette Urban Ministry. There's also Immigration Coalition of Lafayette. There are some resources in Indianapolis as well. CAPS is mental health services, right? Counseling and psychological services. If you need help, you can also seek assistance there. There's a couple other places. The Immigrant Connection out of Logansport provides some free legal or low-cost immigration services. But nothing can replace the advice from a qualified attorney. I want to be very clear that do not, just to save some money, don't try to cut corners and get advice from someone who's not qualified to give advice. We have seen situations where people get into worse off situations because they tried to save money, and then they end up spending a lot more money trying to get themselves out of a bad situation. So just make sure you're getting good legal advice from a qualified attorney or a qualified DOJ accredited representative. That's not an attorney, but someone who's been through training and who can provide some types of immigration counseling. We are about to file my H-1B extension. How could USCIS find out I received benefits in the past? Well, they can ask. They can always issue a request for evidence. On H-1B applications, we're seeing, as we have in the past, requests for evidence can be issued to ask for any kind of information to help them adjudicate the application. I need to apply for renewal of my J visa. How would the consulate find out if I used benefits? Again, they can ask you. And when you're asked the question, you need to tell the truth, because if you lie, then the consequences are worse. If you are lying to a government official in order to obtain an immigration benefit, that could have long-lasting impact on your ability to get a green card. That's also a question on the 485 application. Have you ever lied or misrepresented information in order to gain an immigration benefit or entry to the United States? And I would not want to defend that. I'd much rather defend use of public benefits than lying to a government official any day, okay? I think it's easier to overcome. I never use benefits, but my spouse has. Will we be separated? My J2 spouse has. My J1, J2 spouse has. Will we be separated? So again, it depends on what benefits. It depends on how much. Again, you saw the threshold here for, there's a timeline too. So if you're applicant for adjustment of status, they're looking at over a period of time and in the aggregate. So it's not an automatic, if you got a month of some benefit, you probably do not meet the threshold requirement. I'm a Purdue faculty advisor or staff member. How do I help my students and scholars who are in need? Great question. So if you are trying to help your students, first of all, I'd recommend them to, on-campus resources that are amazing. You have such a great team within your ISS here that they are very much willing to help you. And if they can't, they will be very quick to say that they can't, and they will refer you to an outside attorney. And we are happy to help when that comes. But try them first, because they have a great deal of knowledge and expertise to help you. Again, you have resources here, CAPS, Counseling and Psychological Services. You've got the Lafayette Urban Ministry and the Immigrant Coalition of Lafayette. So do utilize your on-campus resources, and if they can't help you, then call us or call someone who is able to guide you through the process. And that is all of your questions. Do you want to?
Yeah, we'll open it up for questions. We've got microphones on either side of the auditorium. If you have a question, if you can line up quietly. And apparently we've answered everything. No.
Really a couple of questions up here.
So I'm a graduate student, and right now I'm receiving pay from Purdue. Say I graduate in May, and I'll go out to work at a different state. How would the differences in pay affect the poverty guideline? Because in different states, say I got a job in California.
Yeah.
Then how would that be determined in change of status to from F1 to H1B or to the green card?
Yeah, great question. So you can look up the threshold poverty guideline. I did not bring that with me. That would be something to add to the presentation. Hold on, I'm making myself a note. Okay, but they're pretty easy to find on the USCIS website. You can see whether you are making enough money based upon that 125% above the guideline, and for your household. So it depends on how many people are in your household. If it's just one, it's obviously going to be a lot lower than a family of 5. So you have to look at that. And then also, when you apply for an H-1B, built into that process is your employer has to check what the prevailing wage is in that state and that county, the geographical location. So hopefully, if the employer is doing it right, they are going to be paying you what you should be paid by the Department of Labor standards if you're applying for an H-1B, okay? So that's kind of a check in the system. They should be checking that. If you feel like you're not, then that would be something you need to take up with the employer. But make sure also, again, if you're a one person, you should be fine. But if you're a family of 5 and your spouse can't work because they're in H4, then that's a little bit different, because then you've got a poverty guideline maybe that you can't meet on one income. Okay, so you got to check that against the numbers too. Do you have anything to add, Amanda?
Yeah, so the federal poverty guideline is a nationwide chart. There's a couple carve-outs for Alaska and Hawaii, but for the most part, there's one threshold wage for the entire country, as illogical as that sounds, and the only differentiation is between the family size. Yeah. So there's no difference made between Arkansas and California, for example.
Yep, yep. So that's very true, but the H-1B, for the prevailing wages, it is based on geographical location. So if they're pulling the right wage for that area, hopefully it should be based upon, that cost of living and in that particular state. Okay, we'll go over here next.
Hi, thank you for taking the time.
Sure.
This question requires a little bit of context, so I hope you don't mind. So recently there was an issue with graduate pay at this university, and as part of the solution, the university offered loans, like emergency type loans, for people who had been affected by this pay issue. And so what I was wondering was that would this fall under, because you specified earlier that there's in the rule change, any federal, state, local, or tribal cash assistance for income maintenance. And since essentially that's what this loan was, it was to help sustain income over a period of time during which it was disrupted, I was wondering if you could say whether this program would count as a public benefit, seeing that Purdue is a public university.
Right.
Thank you.
That is a very great question, and thank you for all of the detail and thought that you put into that. You're thinking like a lawyer. So I don't think so, because Purdue is, as an institution, would be giving you that loan, or even if it's a scholarship or whatever it is. So it would be classified differently. It's not considered a federal public benefit under these standards and under the list here. I do not think it qualifies. Now, with a caveat that because it's a state institution, it does receive a certain percentage of the budget is from the state, probably 16, 17%, something like that. Very small percentage, okay? So you would have to prove, if they wanted to challenge you, you'd have to prove that you were not part of that 16, 17%, right? And that it came from some different pot of money. And so that's a hard one to prove, because it's usually all commingled into the same operating fund, okay? But I don't think you're going to get there, because I don't think it's on the list. So would you?
Number one, it's a loan, so it's something that you're going to be repaying.
That's true, too, right?
Number two, it's not the public charge rule is targeting federal, primarily federal benefits, some state benefits that are for social assistance, in essence. And that loan it doesn't fall under the overarching purpose of the rule. So I really don't think it's going to be an issue.
Yeah.
Unofficially, without being advice.
Yeah, and I would agree with that. I don't think you're going to have an issue. Yeah. Let's go over here.
Okay, good morning and thanks again. I have 3 quick questions, if I may. The first one is pretty simple. Is there some way we could get copies of these slides or access it?
We're going to be making it available after the event, yes.
Yeah,
Okay.
And I may want to improve it a little bit.
Yeah, that's fine.
Okay, fantastic. Secondly, out of curiosity, you mentioned like a bond of sorts. I was just wondering, when that bond is that returned with interest? Because there's this time value of money, and I was thinking, if I'm giving up money for 10 years, when it comes back to me, it's going to perhaps be worth half what it was in the beginning. And my third question was whether or not you could give us just a brief idea of how this may affect potential employers. Could you give us a sense of the cost to potential employers who may be, sponsoring students who transition from students to working and perhaps also applying for a green card?
Great. Okay. So your first question, no, I do not think there's interest. That would fascinate me if there was. And I don't know when it is returned, because we haven't had bonds before on public charge, and we don't even know. We don't even know if that's going to happen. It brings back the possibility for public charge bonds, but that's not to say that they will even do it. And I don't know. I think it would be returned after you demonstrate that you're no longer a public charge, but I have not found any specific guidance on that yet. I would assume that's forthcoming, I hope.
Yeah, we'll see.
Yeah. Your second question about H-1Bs and your employer obligation, there is a concern. Most of this is falling on you, the intending immigrant, but there is a concern that the employer will be also, they're already afraid of the H-1B process. adding one more layer of complexity to the system is not going to be helpful, especially if it's, you know, causing additional delay or cost factor. So even if it doesn't, there could be a perception that it will, okay? So hopefully it doesn't change too much. And again, it's part of our job when we work with employers is to help them not be afraid of the H-1B process so that, you know, they feel like it's something that isn't a burden on them.
Thank you.
One of the things I want to add to that is with respect to the non-immigrant visas, the H-1Bs, the O-1s, the TNs, the E-3s, the rule was very non-specific about how the change in interpretation might be implemented. So whereas they gave a lot of detail about the adjustment process and the permanent residence process, they've really left the door open for the H-1B process, and we really have no clue of what the impact will be at this point. We're just
Right.
kind of keeping our minds open.
Over here?
Hi, I'm Samira Fatemi, a grad student in botany and plant pathology. I'm wondering what aspect, if any, of this new public charge rule affects students who are here under DACA status or DREAM Act status.
Great question. So there is no requirement to get DACA or to extend or renew DACA for public charge at the moment. But if that person is applying for a green card, so for example, if you have a DACA student who marries a US citizen and they want to seek a green card through marriage, they would definitely be impacted just like anyone else to provide this new form and to prove that they're not going to become a public charge. So I would think that would be it. I think it's going to impact them just as it would impact anyone else.
Okay, thank you.
Yep. Over here?
Hello, I have two questions. One is for me, the other one is for my friend who couldn't attend. The first one is that I'm going to change my status from J to F1.
Okay.
And also I need to waive the 2-year home residence
Yes.
rule. So I was wondering how this rule can affect me regarding the situation that right now I'm working at Purdue and I'm receiving living stipend. And when I asked my PI, she said that it's not related to federal and it is coming from my lab. So is this considered like a benefit
No.
or not?
No. So anything that's coming from Purdue, because if you're like on a graduate assistantship or something like that, you're a quasi-employee of Purdue. And so you are actually working and you're doing something and you're being compensated for that work. And the way that Purdue is compensating you is through tuition remission, some kind of allowance or scholarship or even getting paid. And so none of those things would be considered public benefits because they're tied to your employment at Purdue, and also because they're not on that list of any of those benefits that would,
Yeah, I was wondering maybe it may be considered because they don't deduct tax because it is living stipend.
Nope. No.
No. And the other question is that I have a friend, she had lung infection and she went to hospital once. And after managing the cost, she couldn't pay the cost because it was very too much for her to afford it. So after a while, she went to hospital and she claimed that she's a student and they gave her like 30% off. So she was wondering, is it going to consider like a public charge?
I'm pretty confident in my answer, no. I do not think that a bill that you receive from a hospital that you got a discount on because you were a student does not qualify as a public benefit. Now, if you tried to get Medicaid or Medicare or some federally funded program, the answer might be different. But the scenario as you described, I do not believe that that would be a public benefit. Now, would they take into account your liabilities in that I-944 form? So when you do the I-944, you're going to show your income, you're going to show what are your assets, and potentially what are your liabilities. If you have a great amount of debt, that's where it could come into play to show your whole financial picture. But it's not, in my opinion, it's not a public benefit.
So just adding to that, the law is kind of funny. It uses what sound like normal English words, and then it puts them together and it makes an entirely new concept. So the fact that we have the word public attached to the word benefit doesn't mean that those words keep their normal use. It creates an entirely new, very special concept. So the fact that you get a benefit from a place that is public does not make it a public benefit. A public benefit for purposes of this discussion, from what we know right now, is limited to those things that have been published in the rule as being the capital P, capital B, public benefit.
Yep.
Okay?
Very good. I think that's so important because when you hear this, it creates a panic and a fear in some, or just a misunderstanding of what this actually means. And really, it's exactly that. It's means tested. It's federal. It's it's public assistance, government assistance, okay, and not anything else.
Right. So for people like me who want to change their status from J to F, I mean, is there any consideration that they need to do, or they need to,
At this
cautious?
time, no, because it's a non-immigrant classification. You're not applying for a green card. So at this moment, there's nothing additional or different that you need to do.
Okay.
Could they ask? Yes, they could. Will they? I don't know. I hope not, because this is not isn't applicable. As Amanda said, we don't have any guidance as to how this is going to impact non-immigrant visas. And honestly, I don't think that's the focus. I don't think that's the intent.
Okay.
So could it be an unintended consequence? Maybe. Sometimes there are collateral consequences. That means the people that it intends to impact, it impacts, but other people it impacts too that it didn't intend to impact. That's where I think that might happen. But I don't think this is intended to impact an international student who's coming and changing from a J to an F at Purdue University. Okay?
Okay. Thank you.
Hi, I'm a postdoc here at Purdue, and I think that last explanation of public benefit may have answered my question,
Yes.
but I'll still like to get a clarification. So as a postdoc and on STEM OPT, I have been applying for several grants, and these are government grants like NIH or Department of Defense grants. And I was wondering if that would be considered in this public benefit.
My answer would be no. Those are grants based upon your work and based upon your intended research at the institution. Those are not public benefits. They're grants. They are meant to support you as you're doing your work on a very important strategic and something of national importance that's beneficial to the government. So again, and it's not going. It's for your work. It's not, you know what I mean? So, no.
I think one of the ways to look at it is, again, separate out the terms public and benefit and really try and decide whether it's on the list. But the other way of looking at it is, are you doing something that helps you earn whatever you're receiving? And in that case, you
Yes.
clearly are because of your research.
Okay, thank you.
And I would think that would make you less of a public benefit or public charge because you're not a public benefit, but you'd be less of a public charge because you're doing something to improve your, career and your aspirations and your employability in the future.
Okay, thank you.
Over here?
Hi. When an OPT application is pending, while it is pending, regardless of your grace period, if it has expired or not, you are in legal status, correct?
If your OPT application is pending, are you in status? Yes.
Once you get the decision, let's say it's denied, how much time do you have to either leave the country and come back on a different kind of visa, or change your status, for example, from an F1 to an F2, once you get the rejection after your grace period ends?
I'm going to defer to you on that one.
So this is a pretty particular situation that wouldn't really affect the majority of the people in the room. So I would encourage you to come to the ISS office and speak directly with a counselor, because you're going to get specific instructions from USCIS if your application is denied.
Okay,
Okay?
thank you.
Thank you.
Okay, over here.
Thank you for your presentation. So you talked about determining the above poverty line percentage.
Yes.
So when calculating that, if you are a J visa holder and you have dependents that are working, do you bring in their earnings in calculating that, or is this just
Yes.
discretely the J1 visa holder that is determining that?
Well, you're probably not going to be asked because you're not required to do an affidavit of support or the 944 form on a J. But yes, the answer would be if you were seeking a green card or something in the future and you were asked that question, yes, you would calculate. And part of the question on the 944 is who else is working in your household. If you're, you have a son or daughter that's working, or your husband's working, or whatever, a spouse is working, you have additional income, or are you the sole provider? Okay.
And then my second question is, if you are wanting to change from a J to another status, maybe an F, because maybe your sponsorship is expired or is done,
Yeah.
how would, whether the benefits you've received, how would that count in changing your status? Say you're still a student, but then
Yeah.
your status has to change because you no longer enjoy the benefits you used to from your sponsor.
Okay, let me see if I understand your question. So you have a sponsor under the J1 and you want
Yes.
to change to an F1, which you would
Yes.
no longer have a sponsor.
Yeah.
So in that situation, they are going to help you to meet the guidelines for the new I-20 form, and you're going to have to show, part of the I-20 is showing that you have enough money to support yourself for 1 year for tuition and living expenses, and they will put a number out there, and you're going to have to bring a bank statement or something to show that you have the money to pay for at least 1 year of school in order for them to even issue that I-20 form. So part of the whole student visa process for international students is proving that you've got enough money to support yourself for that international tuition.
Okay, thank you.
You're welcome. Yep.
Hello. So on the list of public benefits, I noticed there is this SNAP.
Yes.
And I know that, or vaguely know of something similar called WIC. Does that also consider as?
Oh, WIC? WIC?
Yes, WIC, yeah.
WIC is not on the list.
Okay. And also related to the various childcare benefits, I was wondering, there are these like really Purdue University, for example, graduate students, childcare grants, and so it's a grant of Purdue University. Does that in some way?
I would say no. Go ahead, Mana.
If it's not on the list, if it's a benefit that is public as opposed to a public benefit from that list, you have less reason to be worried.
Okay,
Yeah.
thank you.
And I wouldn't even say, you're getting the benefit of a child care because you're either working here or going to school here. That's part of the package of your Purdue experience, and you're paying for that in large
And
part.
earning it, yeah.
Right. So, college is expensive, right? And especially for international students, they're paying more than in-state rates. So you're going to have, that's part of the experience of being here. That's not what we're talking about here today. But,
Thank you
but
very much.
great question, because it probably impacts a lot of people who were thinking that same thing. Yep.
So I'm actually a domestic student, but I kind of wanted to do a more broader question for people who are working at Purdue, particularly. Is there anything currently being set aside for graduate students who are international to support them so they don't have to get these assistance programs? Because telling them not to get them is not going to address the issue that they're experiencing right now.
Great question.
That's a great question. Unfortunately, there are no scholarships for international students at Purdue, except a few general scholarships at the undergraduate level and then grad staff appointments at the graduate level. Although we do an excellent job of negotiating for excellent insurance.
Is there any chance of you guys advocating on behalf of the international graduate students to push Purdue to potentially give them additional assistance?
I would say that that advocacy should probably start at the graduate student government. The Senate would be a fabulous place to bring that up because we're legal in compliance, and although we do see some of the challenges that international students face with respect to financial commitments and things like that, it's the students who should be advocating on behalf of themselves, and they do a great job of that. And then we, as faculty and staff, engage with them to find ways to make those types of things happen.
Okay, thank you.
That's great question. By the way, all of you who are students or who are looking for a great research project, I can see a lot of them here. So if you are looking for a final paper or topic or something, this would be a fun one. Go ahead.
Yes, my name is Michael Theodore. I am a career consultant and employer coordinator here at Purdue University. And one of the things that I encounter from time to time from students is how college is just expensive. As a nation, we're already $1.2 trillion in debt. Student debt is an issue. And with that being said, you mentioned something about student debt. If you are seen as a student that has like a lot of debt, that can either affect your public charge, right? So with that being said, can student debt still be seen as a benefit, especially if most of our students are conducting meaningful work, meaningful research experience? And let's be honest, education in this society still has like a great amount of meaning. There is a reason why there are so many students that decide to go to Purdue to chase the dream. So the whole issue with debt, I find to be like a little bit problematic. If it was up to me, college would be free, but that's a completely different discussion. But can you answer that question, especially for the students that may be in this room right now that wants to go to law school or wants to pursue higher degrees that could potentially incur more debt?
Sure. Okay, so I'm going to break it down a little bit because international students are a little bit different population because they are coming here in large part with the funding to support, and the reason why they've been given the I-20 form and actually gotten the visas because they've demonstrated the financial ability to pay for school. And so that's one of the threshold requirements even before getting to the United States. So an international student is going to be in a different situation, and they're probably not getting a lot of financial aid or loans and don't have a lot of debt. Now, there could be exceptions to that, and we can talk about that. But international students in a bucket. Then you've got your other bucket of people who are not international students who might be here undocumented or DACA. And those students are going to be struggling because they're not eligible for any state or federal financial aid, okay? So they're not going to be getting financial aid because they can't get it. They're not U.S. citizens or permanent residents. They have to look for other buckets of funding, like private scholarships and private loans, which are not on this list. Private scholarships and private loans are not considered public benefits. So if you're a student who's, and this is always better anyway, it doesn't matter who you are, find free money. Find free money before you go get a loan. Get a scholarship. Scholarships aren't public benefits. Private loans are not public benefits. Pell Grants are not public benefits. That's not on the list. So, you know, hopefully there are ways, and without getting someone in a public benefit situation to pay for college, which is kind of two different ideas here. And you're right, yes, you show your employability, you show that you're, able to work, then that impacts your case.
Thank you.
And I'm not telling you whether I agree with what you said or not. No opinion here.
Hi, my name is Ahmed. First, thank you for that session. It was very important to know the details about that. I have a few questions here. So the first one is...
Can you speak into the mic, please?
Oh, I'm sorry. I'm too tall. So the first one is the application for an OPT considered a change of status that needs that to be reviewed or not?
No.
It's not. The second question is, something doesn't really click in my mind. So when you were talking about the new rule, you said it's going to be for the past, like the last 3 years that someone like used the benefits for one cumulative year in this last 3 years. Right?
Yes.
And then you also said it's going to be for the future. It's based on the like judgment of the
Yes.
future. And the reason why I'm asking that is I might be now a student and living on the student salary, which is limited, but then I might get enough money to pass that poverty line, but I will be judged for the past that I used some of these benefits before. Is that true?
Yes, it's part of the totality of the circumstances test. So if, in my understanding, again, this has not yet been implemented, but any factors like use of public benefits in the past, applying for public benefits in the past, or that future likely to become, okay? That's very discretionary, but all those factors like your age and your education and your employability and your assets and debts and things like that will help you to overcome anything like that.
So I might have been used before, but still be like,
Yes.
that could be overcome.
Right. It doesn't mean that you will be denied if you received a public benefit, right? There's still an opportunity to overcome.
So no one factor is the harbinger of doom. So just because you check one box off doesn't mean you can't offset that with other factors. It's really the totality of circumstances.
Yeah.
And certainly there's always been within the immigration system an understanding that the past doesn't necessarily lock you into a given path in the future.
Yeah.
Okay. A few things that I didn't see on the list and I wanted to clarify. WIC and PGSG childcare grant was
Right.
two of them. And then there is Purdue offers like every couple of years a need-based scholarship for staff. Is that considered
No.
one of these?
No.
Okay. And the childcare assistance, the vouchers, that is...
Through who? Purdue?
No, not through Purdue, through the government.
Through the government. I don't know. I don't think so.
It's not on the list.
Right.
That would be the starting point. After that, we're not familiar with what you're referring to, so someone, not necessarily us, would need to look at the specifics of what you're asking. But again, look to the list. That's
And then
first
look
place.
where the money comes from. Is it private money? Then it's not a public benefit. Is it state or federal money?
Yeah.
Then it's kind of like a decision tree, okay? Then you ask the next question. Is it on the list? Is it, so you kind of go down the line of your questions, but less likely, very less likely.
Okay, one last question, I'm sorry. You said I'm not going to
And especially if your kids are US citizens, too.
Okay, so that relates to the last question. So you said I'm not going to be penalized if I get assistance for my child that is basically an American citizen.
Correct.
So even though, the question is, even though his eligibility was based on my income?
Correct. Right.
Okay, yeah. Thank you so much.
Yes.
Hello, I'm Vaibhav. I'm a graduate student here. Thank you for this session. My question relates to something which happened in the past. Last year or session, I was on my OPT. During my job search, I passed the last date for enrollment of health insurance. And I could not enroll for, I don't know what it's called, but federal health insurance. So I instead applied for the Healthy Indiana plan, and I was approved for that. I was enrolled for that plan for the last 1 year, but I never used it. it was only eligible for emergencies, I think. So would that fall under any of the categories on the list of benefits, which?
So first of all, it's not on the list, but it
Okay.
is a state benefit. And second of all, you got emergency only, which is not, is exempt from the list. So would you have to disclose it? I think the answer is yes. Would it count against you? I think the answer is probably no.
Okay, I see. Thank you.
Hi, my name is Dr. Lisa Nielsen, and I worked in the fellowship office here at Purdue. And I just wanted to say a few things. So sorry, Angela, this isn't really targeted at you, but just for the general knowledge of everyone here. So there's a lot of language going on about scholarships and whatnot, but at the graduate level, it's really fellowships. And I just want to clarify that even if there's not that many national fellowships from the US government, there are still fellowships and funding opportunities for international students out there. So this statement, which I know is referencing a very particular situation, that there are no scholarships for international students, is not correct. There are, in fact, opportunities, and this does relate to what Angela did say about, there's funding from external companies and other things as well. So I just want to put a point out there for that, that there's still funding you can get, and this is not the funding that's being talked about for that public benefit category.
Right. I think that's such a good point, and I think we need to do a very good job of making sure that we say fellowships and scholarships are not public benefits, because you need to continue to apply for them. I hope that this doesn't discourage people from applying for things like that.
Can I clarify, is that at the graduate level only?
Yes.
Okay. I was speaking specifically to undergraduate funding that might be available, and really there is none. There's not even any financial aid that can be acquired.
Yeah.
Right.
And
Graduate's very different.
Sorry. Also, too, at the university here, it's important to note that fellowships go through the fellowship office, not financial aid. So that's where some of the stickiness comes into play as well. So I'm just talking about grads, not undergrads. Thanks for clarifying.
Great.
Also, too, if I might just put a little note out there, I'm giving workshops on how to find fellowship funding during the October Blitz session for professional development. So look up the fellowship office. Happy to help you. Don't want anyone to feel panicked about that. So thank you for letting me put in that public service announcement.
Thank you.
Remember, a benefit that is public is not a public benefit.
I'm writing that down. I'm going to put that in my presentation.
Yeah, last 3 questions and then we'll be done. This gentleman?
All right, thank you very much for doing this session. We appreciate it under the circumstances. And my question is more sort of generic in nature. And then I'll add a little specific caveat at the end of that, sort of burrow in. It's that, how does this affect how international students file taxes? Because you can be a non-resident alien for tax purposes, for instance, and that can change how you file taxes and what you declare on your tax forms. And then if an international student has taken the education tax credit, I missed a good chunk of the presentation, so I'm wondering if that's on the list of public benefits as well.
Okay, go back to your first question.
Okay.
What was
it's just generic information on how the concept of a public charge, et cetera, within the letter of the law affects how we file taxes.
File taxes. Okay.
Yeah.
Well.
So I think one conclusion would be that the income that you announce to the Immigration Service during adjustment would be in part based on the income that you are declaring in your tax returns.
Okay.
Yes. So number 1, file your taxes. But number 2, it doesn't impact, this doesn't change the tax laws.
Okay.
So there's no change in the tax laws it's not impacting that at all.
Okay.
So keep doing what you're doing, and you will be required, at some point you could be required to provide your tax returns or tax transcripts. So be ready for that. But I don't think it changes how you do it.
Okay. And then if you've taken the education tax credit, does that constitute?
So I got back to this
Go back to the list.
one, and I think, do you mean the education tax credit on your taxes?
On your taxes?
No.
That's not a benefit.
No,
Okay.
that's a tax credit. That's something that you're following the tax laws.
Okay.
So, and that's there for you if you're, if you've been paying for school, you can take up to a certain amount, right? And as long as you're following the law, no, I think that's not a public benefit.
Okay, thank you very much.
Hi, my name is Margaret Haas. I'm a continuing lecturer in the PLACE program here. I teach international students. And I'm also a partial accredited representative with Lafayette Urban Ministry. And my question is, can you say more about employability and how language proficiency factors into that? Because I've seen some information on that in the last couple weeks.
Well,
but it seems very vague.
Exactly. I think it is very vague, and I think until this goes into effect, we won't know. I think employability most of the time doesn't have a lot to do with whether you speak English or not, because a lot of jobs can be done, regardless of English proficiency. So I don't know how that's going to be judged.
There's been no criteria published yet on that. So, all bets are off.
Yeah, what I just heard from clinic is that you might have to prove through courses you've taken or certificates you've earned, some sort of way to prove that proficiency.
So
but it's not defined. Yeah.
It's not. There's no specifics about it. Already in immigration law, there are rules addressing English language abilities. So during J and F processes, you have to document that you have the ability to speak English. The consulate is supposed to address that issue during visa applications. Doesn't always. So immigration law does already incorporate some provisions of that. We don't really know whether or not this particular scenario is going to adopt the pre-existing rules or whether they're going to create new rules. We're going to have to wait and see.
And I would add that as an attorney, and you know this because you help prep cases, but as an attorney, if I am trying to overcome something, let's say I'm trying to prove extreme hardship, or I'm trying to prove that this person is not going to be a public charge. So when I look at my, strategy for doing that, I'm not just going to give USCIS what they asked me for. I'm going to give them everything I can. I'm going to beef that file up, and I'm going to make it strong as possible. So is that one thing I'm going to put in there? Absolutely. But if the person doesn't have it, does that mean they're not going to get it? No. It just means we don't have it to provide in the evidence. So you have to look at, are some of these things interpretations, right? Practice pointers, we call them practice pointers. So practice pointers it's not a requirement on the list, but it's how we as attorneys strategize and go, how am I going to overcome this finding and put my client in the best situation possible?
Thanks.
Half of law is PR, and that would be part of it.
So a suggestion to follow up on that, just for Purdue to maybe offer more classes to help with English proficiency. And then I do have a question. So this is about graduate students. So I've calculated 250% of the poverty rate to be $30,350. And Purdue likes to tell us graduate students how we're getting tuition remission and all these other benefits that make our actual pay much more than our take-home pay. So they calculate it as like $40,000 or $80,000 or something like that. So would that count towards 250% of the poverty line?
So I would think so, because the whole package of your benefits, and also some of the benefits of that to you and to the university is those are not taxable. So oftentimes it's better for you to get a benefit versus get the money on your paycheck, because if you get the money on your paycheck, 40% of it goes to the federal government for taxes, right? But if you get it as a fee remission, it's not necessarily taxable income, right, in that category. So, but I do think that it would still be part of your overall package of, your income. It's offsetting your living expenses. It's like a minister, for example, that's getting a housing allowance, right? That's part of their overall benefit package.
The forms that you list your income and expenses on, the I-864 affidavit of support or the I-134, the new 944, lots of numbers, they don't just ask for a bottom line, they ask for everything to be added up, so it really does give a very holistic picture of your overall situation. And it always has done that.
Thanks. Yeah, thank you for that question. Okay.
All right. For those of you who are still here, thank you so much for joining us today and for the great questions. Angela, I'll let you close, and everybody have a terrific day.
Yeah, I just want to say thank you, and I want to just say a final word. We kind of covered this. Please don't be afraid. Don't make this make you afraid. Get the facts. Please continue to apply for scholarships and things that you are eligible for, and don't apply for something that you're not eligible for. None of that has changed. So we're trying to, navigate this along with you. So please bring your concerns to us. It'll help us understand things better. Thank you.